All righty. Thanks everyone for joining us. Welcome to the do's and don'ts of data utilization, case studies in the food and beverage industry. This event is brought to you in part with our sponsor, Baker McKenzie. We're so grateful to have their sponsorship and their partnership with us. And I am going to hand things over to our Food and Beverage Forum Chair, Christina Conlon from Baker McKenzie, to kick us off with some opening remarks and get our event started.
Thank you, Megan. Good morning, everyone. Thank you for joining us on this rainy Thursday morning in Chicago. As Megan mentioned, I'm Christina Conlon. I'm a partner in the International Commercial Group at Baker McKenzie and chair of the Food and Beverage Forum. We're thrilled to have you today. And I'm equally thrilled to introduce you to my colleagues, Rebecca Laderhouse and Adam Aft. They will be doing some individual discussions and then we'll do a breakout session. First, let me talk briefly about Adam and Rebecca. Adam advises clients on transformational activities, including IP, data privacy, and tech aspects of M&A transactions. Rebecca is an expert on brand adoption, rebranding for Fortune 100 companies, and is a trusted advisor on a wide variety of social media, advertising, and marketing and promotion issues. As I mentioned, Rebecca and Adam will each give a brief presentation, and then you will be sent to a breakout room for a more fulsome discussion, interactive discussion, Q&A session, and we really encourage you to engage in that discussion in the breakout session. Feel free to leave your video off during this initial session, but as you are sent to the breakout rooms, we do ask that you turn on your video for participation in that. Without further ado, I will turn it over to Adam first.
Great. Thanks so much, Christina, for the introduction, and thanks everyone for joining this morning and for the partnership with the Chicago Executive Club. It's great to have the opportunity to speak with everyone, even if it is a bit rainy and dreary outside, as you indicated, but great to have the chance to speak to everyone. I'll just pause, Megan, or otherwise, just make sure you can hear me, correct? I don't want to start talking into the void.
Good. Yep, you're good to go.
Great. Wonderful. You always hate when the presenter spends the first 5 minutes being really happy about everything they're saying on mute, so that's fantastic. So really, this is a topic near and dear to my heart. I spend a lot of my practice focused on data monetization, data rights, and then a number of technological areas related to that, artificial intelligence, machine learning, and otherwise. So it's a topic that I'm really excited about. It has a huge impact in a number of industries and is an area of real growth in terms of opportunities for digital transformation, both internally within the organization and then also externally, whether as a product or as a revenue driver, having these type of opportunities for monetization or uses of data. So at the outset of these types of discussions, though, it's really helpful to ask some fundamental questions before an enterprise engages or as part of the enterprise engaging in a data monetization type project. And really there's three fundamental questions. What is the data and the source of the data that we're even talking about? Who, quote, owns the data? And what are the opportunities and restrictions that exist on that data? So first, what is the data? That seems really basic and fundamental, right? Right at the outset, of course, you're going to ask, well, what is the data? But the reason that I like to raise that question first is it's often a little bit more complicated, and really digging to the details of exactly what is the data and the source of the data will influence the project as you go forward, will influence understanding how are the rights in the data allocated, what are the restrictions, and the questions that follow. So just to take an example, the enterprise may say, well, we have a lot of consumer data, customer data. We want to use the customer data, right? Well, conceptually, that makes sense. It's a category, it's nice, it's defined. But once you start to pull that thread a little, it's, well, what does customer data mean for our enterprise? Does that mean our email contact mailing list? Does that mean our point of sale data? Does that mean data we capture through our website, social media, and other digital channels? Is that just standalone data that's maintained by our enterprise, or is that data that is maintained by our enterprise but linked to broader profiles, profiles relating to online behavioral advertising or otherwise? So really, what is that data when you say customer data? What does that really mean? And so it's important to do that because you can see just from this kind of simple initial thought exercise of customer data, that can mean a whole number of different things. And as you'll see as we continue the discussion, knowing what that data is and where it's from will really impact those questions. So the what is the data, and then part of that question as well, of course, is the source of the data. So if you know what the data is, for example, if you do decide, well, what we really mean is we could be doing more with our customer email mailing list, for example. Okay, well then what's the source of that data? Is that data that's only been captured through e-commerce and opt-in? Would you like to receive our newsletter? Is that data that's somehow been captured as part of customer loyalty programs and you have that email contact? Really, what is the source of the data now that you've kind of identified the specific data that you're interested in or that you're looking at an opportunity about? What is it and what is the source? So that's the first question. It really helps to identify. You can go through any number of examples with respect to different types of data and data categories and seek to answer those questions at some level of detail, which you'll see now as we go forward. What does that really mean? What's the impact? So the next question that I really like to ask is, who owns the data? Now, the reason I really like to ask that question is it's the question we always get asked when our clients come to us on a data monetization type project. The first question that we always receive is, who owns the data? And interestingly, you happen to have myself and Rebecca. We're both in the intellectual property group here at Baker McKenzie. So you'd think, great, we've got the right people to talk to. Who owns data? That sounds like an IP question. There's probably some really complicated IP answer here. And unfortunately, when you go to unpack it, the answer is a little bit more complicated. And as much as I would love to say it's purely an IP question, it really isn't, unfortunately, a purely IP question. And the reason for that is there's no statutory or regulated framework for ownership of data like you would have with other types of intellectual property. So let's just take, for example, to distinguish it from a patent right. So a patent right will actually protect for the 20 years the process or the inventive steps that you've taken with respect to some innovative type of process. And then the law confers, at least from a US perspective, the US Constitution and then the Patent Act, actually confers upon the right holder a specific set of rights. 35 USC, 35, Chapter 35 of the United States Code specifically says, here are all the rights you get if you're a patent rights holder. And it's very prescriptive. There's a statutory structure for the protection of that intellectual property. When it comes to data, that doesn't really exist. There are some limited aspects of an existing IP right structure that will apply. For example, from a copyright perspective, there may be certain expressions of organized data sets that have some limited copyright protection. To the extent that the data that we're talking about, and this starts to go back to those first questions of what is the data and where is it from, to the extent that that data has some way of being protected in a proprietary database that's not exposed and isn't really a public data source, there could be trade secret protections where there's an ability to keep it confidential and still derive value from it. So there are some aspects of existing IP law, copyright, trade secret, or otherwise, that could protect aspects of data. And if you look more broadly, there are issues surrounding data, such as a machine learning algorithm or otherwise, that maybe you could start to see there is some patentable subject matter. So some of those underlying IP structures do protect it. But for the most part, data rights and who owns data really goes back to that first question, which is why I like to ask it, which is what is the data and where is it from? And the reason that that matters so much is typically the allocation of rights to data is really one of contract. And so if it's a contract with a third party, where the enterprise is contracted with a supplier, especially in, for example, a cloud service type supplier. Maybe the contract expressly allocates rights to the data. It specifically says one party owns the data, or one party has the following rights to use the data for certain purposes. And so then the question of who owns data isn't an underlying IP question, but is instead a contract interpretation question. And so understanding that what is the data and where is it from is really essential, because it's what empowers you to answer this question of who owns it. If the contract isn't another business-to-business third party, but instead between your enterprise and a data subject, a person, it's still a question of contract. What are the promises that you've made to that person? What had your company said in a privacy statement or a privacy policy that we will or will not use your data this way? There is, of course, when you talk about data privacy, there is, of course, an entire underlying legal regime, ever changing in multiple jurisdictions across the US states, across the globe, of course, as well. But it has that contract piece, which is what is your enterprise agreed to with the data subject within the confines of what's permitted by the underlying applicable law. And so that's really what tends to drive the analysis, isn't the who owns data. And then even there, once you start to drill down a little further back to the business-to-business contract allocation example, it's not even as straightforward as it necessarily may seem, because you may say, great, my contract allocates data rights. Especially like I mentioned in the cloud service space, the contracts do tend to be a little more specific on data rights allocation. But oftentimes the contract may not say exactly who owns the data and who doesn't. And so then it still is a question of contract, but it becomes a little bit more complicated. And it becomes a question of, is this data that is confidential under the definition of confidential information? Or is this data that maybe was confidential, but when you think about it, actually is really public data? And so it would fall within the four little Romanettes, right, that you always see at the end of a confidential information definition that says, it's not confidential if it's otherwise publicly available, if you don't breach your confidentiality obligations, right? So then it becomes this much more complicated contract analysis, confidential information analysis, in order to determine who owns data. So now we've got a bit far afield, right? The initial question is great. I've got the IP layer, who owns data. It's an IP question. And we've kind of worked all the way down to see it's really a much more complex question sometimes. And it's a question that takes an important understanding of the what and the source, and so in order to be able to complete that analysis and be able to look at your contracts and say, okay, we've now diligenced our own contracts. We now understand that for this customer data that we have with these third parties, business to business, with these individual data subject customers, we now understand really what are the rights and who owns the data. And then that leads you to the final question, which is, what are the opportunities and restrictions? So we know what the data is, we know what the initial rights allocation is, and so now where are the opportunities, where are the restrictions? The opportunities really is the exciting part, of course. There's opportunities for, again, considering a product, right? Is the data valuable enough that our enterprise could actually have something we could sell, expressly really package up the value that we have from this data and sell it as a product? Or is it an opportunity to say, with this data, can we drive better outcomes, right? If we're a quick service restaurant, can we better understand from our data what types of meals a customer may be interested in, what would be complementary items on the menu that would be really interesting to a customer, and can we get those types of insights from our data in order to drive better outcomes in order to leverage those opportunities? So that's the really kind of exciting part. The restrictions part is going back to, as I had referenced, especially, for example, from a data privacy perspective, what does the law provide in terms of confines? What are the key considerations we have in terms of what the law says we may do or may not do? If we're talking California, what constitutes the sale under the California Consumer Privacy Act? If we're talking about e-commerce and digital, what restrictions are there from an online behavioral advertising perspective? What are the complications we may have with our opt-outs and our management with the Digital Advertising Alliance, and the rights the data subjects may have and how they control their data. And so the restrictions are really multifaceted to understand the underlying legal regimes. And then, of course, going back to that point about contract interpretation, if you've interpreted the contract and understood that your enterprise has rights in the data, have you also identified in that contract, are there any restrictions that your enterprise is committed to say, yes, you can use the data, but, and whatever that but is that factoring into how you and your enterprise are viewing the data and the data monetization opportunity? So that's really the kind of outset, the way that I like to frame the discussion. Again, it's the what is the data and the source, who owns the data, and then what are the opportunities and restrictions for the data. So with that, because I'm sure everyone has now completely exhausted an 8 a.m. deep dive into data and IP rights around data, I will now turn it to Rebecca with a very exciting topic, more in the exciting social media influencer type world. Rebecca.
Well, that's kind of a big setup there, so I don't know, but we'll get into a little bit different topic here with social media influencers and their agreements. So I'll talk a little bit about the risks that the arrangements can pose for your company and some thoughts about how to reduce those risks. We'll talk a little bit about what social media influencers do and why. And if there's time, we'll conclude with a current enforcement example or two from the food and beverage area. Let me know if you can't hear me. It looks like everything is going well. All right, terrific, thank you. So more than likely, you're familiar with what social media influencers are, and chances are your company is already using them for certain kinds of targeted advertising. Especially if you advertise directly to consumers. If you don't advertise directly to consumers, maybe you're using business customer testimonials and endorsements in your business-to-business advertising. And much of what we're discussing today will still be relevant. The internet and social media have provided companies with an enormous opportunity to use the gathering of endorsements and testimonials by consumers to enhance brand awareness and promote sales. Using social media influencers is really just a new way of presenting a customer endorsement or a testimonial in your advertising. It's become increasingly common for social media personalities, many of whom are musicians, actresses, or athletes, to post photographs of themselves using and enjoying recognizable branded products and services as they go about their daily lives. It's hoped that a posted selfie of a celebrity drinking a particular tea, a smoothie, or sitting down to a restaurant meal might influence fans and social media followers to make similar purchases. These posts are often endorsements for which the influencer receives something of value from the company, whether that's free product, money, or the chance at a sponsorship agreement. This sort of tagging, pinning, and posting about a brand is an endorsement, and it may require certain disclosures. If you're less familiar with the social media influencer phenomena, and you've managed to survive this long without keeping up with the Kardashians or watching a documentary about the Fire Festival, you might be wondering, why do companies get involved with social media influencers or partner with the agencies that employ them? In certain age groups that are hard to reach with television and print ads, reaching them through social media on their ever-present smartphones might be the most effective way to reach them. Also, some of these younger consumers might perceive there to be some added authenticity with these online posts that they don't experience with regular advertising. And finally, influencers can create a buzz about the product or an event, especially when the media picks it up. It's always been the law that endorsements and testimonials must be truthful and not misleading. But in recent years, the Federal Trade Commission, that's the FTC, which is the primary government regulator of advertising, they've revised their guides concerning use of endorsements and testimonials to specifically address social media use, such as blogs and posts by social media influencers. Particularly, the guides require that any material connection between the influencer and the brand be fully disclosed. This includes any business, employment, or family relationship, or monetary or other form of payment, including receipt of free products. The disclosure of the relationship has to be clear and conspicuous, and it has to be made early in the post. For example, by avoiding the use of hyperlinks and avoiding the need to scroll down to find the disclosure. For instance, hashtag ad or hashtag sponsored needs to appear before the more button without requiring scrolling or linking. Also, any claims about the product, for example, about the product's performance that are made by an endorser will be attributed to the company. In other words, the company will be held responsible if an influencer makes statements about the product that are untrue or for which there is not support. You can't use an influencer to say something about your product that you couldn't say. For example, you cannot make environmental or medical claims about your product without reliable scientific support, and neither can any of the influencers that you employ. Non-compliance with the FTC guides can result in administrative action, and it can be punished with penalties ranging from written warnings up to significant civil fines. In addition to the risk of enforcement for non-compliance by the FTC or by the states under their little FTC Act, there's a risk that a competitor or a consumer might complain. And of course, there's always the risk of bad publicity if an influencer goes rogue and fails to disclose that it's being paid, or it makes some statement about your product that can't be substantiated, like it cures cancer or it prevents COVID. So how do we reduce the risk of non-compliance by your social media influencers? First, you'll want a written contract with your social media influencers and the agencies that employ them on your behalf that clearly states that the influencer's responsibilities regarding proper advertising disclosures. That the contract should include specific guidelines for influencers, for example, requiring the hashtag ad at the beginning of the post, or that they include some statement like, brand sent me these smoothie mixes and this blender for free. Perhaps include a list of claims about your product that they can make for which there is support, or a list of areas you want them to stay away from. Hot buttons to stay away from right now include any claims about COVID. The contract should also include provisions for breach. For example, the right to terminate and cease payments, the right to require that non-compliant posts be removed immediately. In addition, to reduce the company's risk, you'll want to choose your influencers carefully, monitor their posts, and document your company's supervision and monitoring of the influencers' posts. With that background in mind, let's talk about a case from the spring. In March of this year, the manufacturer of a detox tea called Teamy and its owner settled a lawsuit brought against them by the FTC for $15.2 million, which is also the amount of the total sales of the product, for failing to make clear that posts made by celebrities on its behalf were paid endorsements. Why such a stiff penalty? Usually when we see this sort of enforcement, there's more going on than just a failure to make a disclosure. Well, in this case, Teamy had been formally warned several years before. Teamy had received a warning letter from the FTC in 2018 about its need to adequately monitor its social media influencers, including the requirement that disclosures that these are paid endorsers appear at the beginning of any post. Thereafter, Teamy instituted a social media policy, and its influencers that required that disclosures must appear before the more button, and it stated that influencers needed Teamy's approval in advance for posts. All good, right? Nope. In practice, the posts were not complying. Either the pre-approval process was not followed in all instances, or the non-compliant posts were not caught during the pre-approval process. For whatever reason, a significant number of celebrity endorsers, including Cardi B and Jordan Sparks, had posted photographs of themselves holding Teamy products and touting its benefits. In most instances, there was some disclosure that these were paid endorsements, but the disclosures were not made early enough in the post so that consumers would notice them on their phones. The FTC complaint explains how the posts will look different on different kinds of devices, and that the disclosures must be clear and conspicuous, even if the post is viewed on a tiny telephone, which is now how most of these are viewed by consumers. Under the agreement with the FTC, Teamy is required, at a minimum, to provide each endorser with a clear statement of his or her responsibilities to disclose, and obtain from every endorser a signed and dated statement expressly agreeing to comply. There's a slightly easier process for confirmation in the case of very small endorsers, which in this case is anyone receiving less than $20 a month who can confirm with an email. TIMI is required to establish, implement, and maintain a system to monitor and review the representations and disclosures of endorsers, including reviewing each post promptly after publication. And again, there's a slightly different and easier process in the case of these very small endorsers. TIMI must immediately terminate and cease payment to any endorser who's failed to adequately disclose that it's been paid. And TIMI may provide an endorser with an opportunity to cure if it reasonably concludes that the failure to adequately disclose was inadvertent. But this can only happen once with an endorser, and the next time, the termination must be immediate. And TIMI must create and maintain reports showing the results of the monitoring. TIMI's agreement with the FTC is instructive for what the FTC expects in your contracts with social media influencers and how it expects you to monitor their posts. It looks like we might have time for one more example from the food and beverage area. In April of last year, the FTC went after a San Francisco snack food company called Earthbox, which falsely implied that customer reviews were independent. The FTC's rules about disclosures apply even in the case of ordinary consumer endorsements. The social media influencer that you incentivize doesn't have to be a celebrity. Understanding the importance of customer reviews and ratings, Earthbox set out to improve its rating. After launching a new review program, Earthbox's reviews jumped from 9 completely negative reviews in 2016 to 695 reviews in 2017. Of these reviews, 612 were positive, 68 were negative, and 15 were neutral. How were these amazing results achieved? Well, it was not necessarily because of any improvement or change in the product. The vast majority of these positive reviews were submitted pursuant to an incentive program where customer service representatives at Earthbox encourage customers to post positive reviews by asking the customers to provide to Earthbox a screenshot of the positive review, which review was also required to falsely state that it was independent and unpaid. After customers provided this proof to Earthbox, they would receive a free snack box, and the customer service rep would receive a bonus. The FTC filed a complaint against Earthbox and later announced an administrative order settling the FTC complaint, under which Earthbox was required to pay $100,000 to compensate customers. And it was barred from making similar deceptive statements in the future. Moreover, if it uses incentivized reviews in the future, it must provide each endorsing customer with a clear statement of their responsibilities to disclose that they received something of value. They must obtain a signed and dated statement from each endorser, and they must establish a system to monitor and review the disclosures and create reports showing the results of the monitoring. I hope this discussion has been useful, and if you have any questions or comments, please join my breakout group and we can discuss these matters further.